All right, I'm calling the proceeding of Department of Health, State of Hawaii versus the United States Department of Navy, docket number 21 UST-EA-02. May I please have appearances of counsel, please?
Good morning.
Go ahead.
Good morning, Mr. Day. My name is Wade Hargrove. I'm a Deputy Attorney General. I represent the Department of Health in this matter.
Thank you.
Good morning, Hearing Officer Day. My name is Craig Jensen. I'm the Associate General Counsel for Litigation for the Department of the Navy, and I represent the Department of the Navy in this case.
Thank you.
Good morning. I'm David Henkin with Earth Justice, and with me this morning is Kylie Wager-Cruz, also of Earth Justice. We represent the Sierra Club, the proposed intervener.
Thank you very much. So just to start, I'll note that obviously it was a filing that we received, or at least the hearing officer received later in the afternoon. Upon receiving it, and this is just for the record, we determined that the prudent course would be to just temporarily take the hearing that was scheduled for tomorrow at 9 off the calendar to address the pending motion to intervene, while also trying to resolve this issue in as expeditious a manner as possible so that we can eventually proceed to an evidentiary hearing either with or without the intervener, proposed intervener, as the case may be. And so anyway, that was just generally the lead into the what happened last night. So I guess I'll just begin, and so we'll just begin by speaking about the motion. Mr. Hargrove, had you have a chance to read the motion?
I have, thank you.
Yeah, you have.
I have, yes.
Okay. And just sitting here now, do you know if you have any objection to the motion?
I do not object to the Sierra Club's intervention in this matter. And I would, however, having reviewed the motion and granted my time to do so was somewhat constrained due to the fact that I was preparing for a hearing that was scheduled to begin today. I would note that the Department of Health takes exception with a number of the representations with respect to the adversity, the characterizations of the department's position vis-a-vis the Sierra Club's stated preference, or I should say preferred outcome in this matter. It is not clear to me where any misalignment may or may not be, and I'm sure counsel can inform me of any perceived misalignment, but I would just note for the record that the state, and this is the Department of Health, was prepared to proceed today, as is evident by the way the order is drafted and the nature with which I've conducted myself in the proceedings thus far. The Department of Health thinks this is an urgent matter. It is an emergency order. We think the sooner the better. And from reviewing the motion, it's not clear to me that the Sierra Club wants anything other than what the Department of Health wants, and that the most expeditious resolution of this would have been to allow the hearing to proceed and for the Department of Health to make its argument that this is an emergency and it should take effect as soon as possible, that the entire four corners of the EO in this case be implemented again as expeditiously as possible, i.e. immediately. So again, I just want to make that representation that that was the position of the department. That would have been the arguments that were made today, that it should be, the EO should be placed into effect and prejudice the Navy in the way outlined in the EO. And so I would just say that it will be, I have great interest in hearing what the Sierra Club's position is with respect to the need for their intervention. But I want to reiterate that the Department of Health does not object to their intervention. Okay.
All right. So let's just keep it there. Okay. So no objection to intervention. Mr. Jenkins or Jansen, do you have a position at this time on the motion that you would be able to state, or if you plan to oppose?
Yes, sir. And it's Jensen, Jensen. Yes, I have read the motion and I am considering it, and I likely will oppose the motion. And here's why. At first read, it seems like the motion itself is inconsistent with the Hawaii administrative rules. And in particular, I point to Hawaii Administrative Rule 11 TAC 1 TAC 35, which addresses intervention in Department of Health contested cases. Specifically, that rule states that motions to intervene must be filed 10 days prior to the hearing. Sierra Club's mistaken when it suggests that there is no hearing or that no hearing has been scheduled. And that's on page 4 of their motion. As we all know, there has always been a schedule with regard to the hearing. It was originally scheduled for the 7th of December, and that's by the emergency order itself. Hearings Officer Jacobson moved it to this Thursday, which I guess would be the 16th of December. And then, of course, the Department of Health rescheduled the hearing for today when they removed Hearing Officer Jacobson and replaced him with you, sir. Well, we do intend, I believe, to object. Obviously, it's hard to make a final position as we're still considering the motion, but we are opposed to the intervention at this stage, sir.
Okay, thank you very much. I think, well, actually, let me just back up real quick. Okay. So to the issue regarding, just very briefly, why we needed to, or at least the hearing officer determined that at least taking the matter off the calendar for tomorrow was necessary was one, my understanding of that rule, and I looked at that rule that was cited by Mr. Jensen, but obviously there hasn't even been 10 days that have elapsed since the emergency order was filed on December 6th, one. But two, the Hawaii case law is very clear that this is something that we should be taking very seriously. And ultimately, we need to make a determination on this point before we can proceed. Now, what we will do is do it expeditiously. And so in that respect, what I hear is Mr. Hargrove is not opposing the motion to intervene. The U.S. Navy is, or is at this point in time, planning to oppose the motion to intervene. Mr. Jensen, how long do you think it would take for you to come up with an op, noting the exigencies of the circumstance?
Well, noting the exigencies of the circumstances, which, and again, the Department of Health and the Navy do not agree with regard to the exigencies, as you well know from yesterday's status conference, and principally the Department of the Navy's position on that is based upon the Secretary of the Navy's suspension of operations at Red Hill, which removes which is the only condition within the Department of Health order that has immediate application. So putting that to the side, we have reviewed or have started to review Sierra Club's 130 pages of briefings, and we do intend to file, at least at this stage, an objection or an opposition to their motion to intervene. I would propose that in light of the time frame of 10 days that's set by the Hawaii administrative rules for serving motions to intervene, that would be appropriate time frame. Well, I know that's too long, but that a week would be an appropriate time frame for us to file our response. Sir.
If I may.
Please.
We are aware of HAR 11-1-35, and we appreciate, Mr. Day, you're mentioning that it would have been impossible for the Sierra Club to protect its interests by filing a motion to intervene 10 days before any hearing that was set, because we haven't even been 10 days since the emergency order was issued. We would suggest that the Department of Health should proceed consistent with the statute and issue an emergency order that is immediately effective, with a contested case to follow as contemplated by the statute, rather than make the emergency order contingent on first having the contested case. That would relieve, and if Mr. Jensen wants 10 days to respond to our motion to intervene after the order taking effect, the interests of the people of the state of Hawaii would be protected, the people of this island would be protected. We have no interest in delaying the immediate implementation of the emergency order And the statute as written provides an opportunity for Department of Health to issue that emergency order effective immediately, and we encourage them to do so. If we are going to go with the order stayed pending the contested case, if the only issue is whether the 10 days has been satisfied, we see no reason why the Navy should need more than a couple of hours to brief that issue, frankly, and we'd be happy to waive any reply brief and present any argument in response to the Navy orally. The last thing that I should mention is I'm not sure if everyone on the call is aware, but we received by email a couple of minutes into the call an email from the attorneys representing the Board of Water Supply, indicating that they too intend to file a motion to intervene today. I raise this as a courtesy to all because we're all here. The attorneys for Board of Water Supply have offered, if it's acceptable to the hearings officer, to join this call so that any scheduling, they can participate in those discussions. So I guess in summary, we think the Department of Health should issue an emergency order pursuant to the statute that's effective immediately. We can take as much time after that with the contested case as the Navy would like to respond to the motions to intervene.
Okay. Well, let me just say, with respect to any, the emergency order or the substance of the emergency order, I don't believe it's the hearings officer's job at this point to do anything. That's not my kuleana. I'm just dealing with what is before me. And so that's all I'm going to say about that. And the record speaks for itself. I will say that with respect to the issues of exigencies, it is not merely, what facts may or may not be disputed, but I also believe that it is my directive that has been given to me by the Department of Health in the order appointing me substitute hearings officer to move forward with this hearing with absolute speed. This is clearly my directives are to move forward as fast as possible. With that being said, I do also see that there is some sort of filing now in my email regarding a new intervener who is, as you said, the Board of Water Supply. Okay.
And if I may, Mr. Day, I just, having heard Mr. Hinkin's suggestion that we at least make some consideration of whether or not it would be feasible to allow BWS's attorneys to present themselves today, again, in the nature of expediting the proceedings as much as can be done within reason. I'm certainly amenable to having counsel for the Board of Water Supply make an appearance today. For the record, I have no objection to that. And again, if that facilitates the expeditious resolution of some issues.
Okay. Mr. Jensen, any statement regarding having the Board of Water Supply's attorney appear on a call? Maybe we would take a brief continuance, come back.
I'm available for any call that the hearing officer directs. My position with regard to Board of Water Supply intervention is the same as Sierra Club's, I believe.
All right. Let's just take a brief 5-minute recess while I will consider what has been said, and we shall move forward. Okay? And so please be back in approximately 5 to 10 minutes.
Are we going to keep this link, sir? And then just keep it
Like, we're just going to go off the record.
Okay.
Okay.
Thank you.
All right, please go off the record. Okay, so in light of the filing of a second motion to intervene, as I understand it, I haven't really had a chance to look at it at all yet. I believe that it makes sense at this time to just, as we're dealing with this issue with respect to Sierra Club, to just deal with them all together. So what I'm going to suggest is that we meet again at 11 o'clock. We will be in contact, or we'll contact BWS and ensure that they're aware. And then I don't know, Department of Health, are we going to circulate a new link once we have the new name of the once we have the name of the attorney who would be appearing?
Yes, we can.
Okay, so please expect a new link for 11 o'clock this morning. Okay. Anything else to raise at this point?
No, Your Honor.
No, sir.
Nothing further from me. Thank you.
With that, see you at 11. All right, this is closed. Thanks.
Thank you.
Off the record.